Hey everyone, Harry here to talk about the trial schedule in the Mar-a-Lago case set by Judge Aileen Cannon. All right, the headline here is the trial date itself, May 20th, 2024. A lot of people in the commentary said, oh, she sort of called it down the middle. Government didn't get all it wanted, but it did okay because she didn't set it after November 2024. I disagree. It's not as if she did anything outrageous. However, I think the bullet that the government dodged was not a real bullet. There was no way that Cannon could have put it after November, even though that's what the Trump team had wanted. Even if she's thinking as their most ardent supporter, that's not how things could start out. In fact, it was a pretty forced move, I would say, because as they knew, this all might change, but they're looking at complicated schedules, and we will be all the way through. March and April are the trial in Manhattan. January is the in Manhattan on the criminal charges, and January is E. Jean Carroll. So May is about, I think, as late as it could have been and as soon as it could have been. So I've been a little bit in a contrary view from a lot of my friends and colleagues, except to be fair, what they've all said is May 20th. That's a good date. Now we just have to make sure it holds. Yeah, well, that of course is the entire point, because what this, it's now been circled on the blackboard, but Aileen Cannon and Trump themselves are wielding a big eraser that they very much hope to use. The second, and here most important date, most people have not focused on this, was in late April, when there will be a hearing on the use of the classified documents. We'll talk a fair bit more about this down the line, but basically, in a case such as this, the government, to prove its case, needs to use some documents that remain classified. And that's first why the defense attorneys have to get security clearances, which they should really be getting more quickly. She's been, Aileen Cannon, I think, pretty easygoing with them. But then they go over it. The court also has one and goes over it, and the government does, and they negotiate out what can be in there to protect the basic security interests of the United States. And there have been instances, in fact, there's a name for it and everything in these classified cases, in which the defense has stood its ground and said, we have to have this information that's in there to prove the case. And the judge has agreed that you can't prove the charges. It's not fair to the defense to expurgate that part. And the security hawks in DOJ, the intelligence folks, said, you may not do this, and DOJ has had to fold up its tent. Now, that really should not happen here, and it's been designed not to, especially because the content of the classified documents are just not a part of the charge. They are that they're classified to a certain level, and that they are national defense information, which is pretty clearly established, and it doesn't matter to the DOJ's case. But this is one way in which Aileen Cannon, either just by sympathy with a Trump argument, or if she wanted to put her thumb on the scale, this is the best opportunity. So come April, there'll be skirmishes in advance, but you can imagine just fights lasting literally months, and that would get Trump he starts out a year after, May 20th is about a year after from the indictment, and it could get him past the finish line that he wants to get to, which is in November. All right, that's the big date and the biggest opportunity for Trump to delay. There are others, but the bottom line here is, other than this classified aspect, which, as I've suggested, really doesn't matter here because content doesn't matter here, it is a straightforward case. It really should not keep Aileen Cannon from, moving with dispatch. We have a new date in November for the filing of all pretrial motions. That's really that. And if they make, they can argue that jury selection might take longer than it normally should, Trump, security, and the like, but not more than a week longer than it otherwise should. So what the next big opportunity after the classified documents issue will be various pretrial motions, but they are lousy and simple in the sense that they just require her to make rulings on the law. For example, he's going to make a big stink about supposed prosecutorial misconduct having to do with a short discussion with Evan Corcoran by one of the government lead lawyers. It really doesn't amount to anything, and she should make quick work of it. Evan Corcoran, one of the government lawyers, that'll be an interesting motion. Remember that a previous judge has held you could use his discussions with Trump, and he could be forced to testify notwithstanding claims of attorney-client privilege. She might revisit that. She might reverse it. That would really hurt the government case. But it shouldn't take months to do. And the other main thing he has, the Presidential Records Act, is just complete doggerel. It doesn't figure in this case at all, notwithstanding that it's their main refrain when she pushed on them in the hearing. What do you got that's going to make this complicated? That's what they said. The interplay between the Presidential Records Act and the criminal charges. That interplay is precisely zero. And it should, even if she messes that one up, it should take no time to do it. And if she does mess it up, that's something that I think the government could go to the 11th Circuit and possibly even get her recused. She is sort of sitting there with 2 strikes on her from bad rulings in the very preliminary skirmishes back a year ago. Okay, so bottom line here is the trial date, which is playing as pretty good for both sides, to me is just, it couldn't have really been much later, and it couldn't have really been much earlier. So no great points one way or another for her there, to put it, in a less jocular way. It doesn't tell us a whole lot about whether she, for reasons either of not having the experience and gravitas to manage a courtroom, or because she's naturally sympathetic toward Trump, whether she'll be conducting the trial, and especially the scheduling of the trial, in a way that will displease or will seem biased to the department, and more importantly to the country, will make it very hard to have the trial by November that public policy really cries out for. So that's the number one headline then. Other than the classified stuff, it really should be easy. If that classified stuff doesn't come up until after it is on the schedule in April, then we're already looking at tailwinds for Trump to be able to get delay and to bring up different things that give him a month or two, and that get him over the finish line. That's the danger that we have to keep watching for. As I've said, the classified stuff in April will be the biggest tell, but before then, it'll be important to see whether when they come and say, we need more time to brief this or that motion, or whether when she takes them under submission, does she eat up a lot of time there? So we're already have lost the May 20th date before we even get to the big showdown on classified documents. So there you have it. For now, it'll be relatively quiet, but we'll get some real indication when the pretrial motions come in and the responses. So there you have it, the Mar-a-Lago trial schedule. We're going to watch it close and knock on wood that it can get there by November 2024. I don't think we have grounds for either great confidence or pessimism right now that that's how things will go. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.